Parliament, that is the legal department, was served yesterday as far as the ruling of the Speaker of Parliament is concerned. And we are here, Nanaya, NDC, MPs, trying to say that whatever the Speaker of Parliament said, with the greatest of respect, is bullshit. And people are not going to adhere to the rulings of the Speaker of Parliament. The Speaker of Parliament draws its power from the Constitution itself. As members of Parliament, we draw our privileges, immunities, our powers and everything from the Constitution. We cannot be seen.
Well, let me just say that we've been joined by long-standing political scientists and then also one of the leading members of the ruling New Patriotic Party, indeed contested to become the chair of the party as well, contributing to our national discourse when it comes to governance, Dr. Amakoba, the distinguished personality adjourned. Good morning to you, sir.
I'm not done with my submission.
No, wait. Good morning to you. I just want to establish him so that. Good morning, sir.
Oh, you are doing well.
Okay, great. Just be monitoring the television and stay on the line for me. Vincent, continue.
So we cannot be seen
to
be disrespecting the ruling of the Supreme Court. That is number one. Number two, Nanaya, indeed, as you said, you're not a lawyer. If you come to the Constitution once again, Article 1(2), which says that the Constitution shall be the supreme law of the land, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void.
Why is this important?
It is important because he juxtaposed the Constitution to that of the MPP Constitution. I do not have...
He also read from...
Yes, so hold on. I'm coming. I'm making a point. Hold on. Nyabotre, I'm coming there. Hold on. You are talking about the fact that...
He's been a gentleman this morning, please.
The MPP Constitution allows a member to forfeit his membership if he decides to contest on the ticket of another party or goes independent. But that is where he gets it wrong if he wants to interpret what cross-carpeting is. Because cross-carpet is what happens in the chamber instantly. If you want to leave MPP and cross the carpet to the other side, that is cross-carpeting. You cannot tell me that I have declared an intention that I want to be part of the next parliament, not on the ticket of the party that I am part of, but on a different political ticket. Vincent. Then you tell me that because of that,
Vincent,
I have no more power. That is why I wanted
to... You are a legal practitioner.
Yes, that is why I wanted to...
put this to you. You're a member of parliament.
Yes.
You're Otafo.
Yes.
That's your constituency.
Yes.
So, let's say you go independent.
I declare to go independent, to join the 9th Parliament as an independent candidate.
You have the Electoral Commission recognizing you as an independent candidate.
Yes.
On December 7th.
Yes.
2024.
Yes.
And currently, serving in the 8th Parliament.
Yes.
You are a member of Parliament on the ticket of the MPP.
Yes.
You say that the MPP will accommodate you as a member of Parliament in just some few weeks to that December 7 and allow you to go to Otafo and be campaigning against an MPP candidate.
Yes.
Just because you left the MPP, because you think you have the mass support base of the constituents of Otafo and indeed members of the MPP, because it is a stronghold of the MPP.
At the time that I was contesting, I contested on the ticket of the New Patriotic Party. The social contract that I had with the people was for me to be in Parliament for 4 years on the ticket of the New Patriotic Party. The 4 years ends on the 6th of January. It does not stop me from taking different steps or other steps to be part of a different parliament, i.e. the 9th Parliament, on a different ticket.
So why then in 2020 did we have the President of the Republic of Ghana, Nana Addo Dankwa Akufo-Addo, indeed go to Fomena, go and stand on the party platform, campaign against a member of parliament who stood in the last parliament? Please,
so that he does
let me pose my question. Do you want to answer the question for yourself?
I want to listen
and pose
to
by
you,
yourself.
I know where you're going.
The president went on the campaign platform.
Yes.
Campaigned against the member of parliament representing the MPP in the run-up to the end of the 7th parliament.
Yes.
And that member of parliament will be contesting as an independent candidate in December.
Yes.
On December 7th of 2020.
Yes.
And you are saying that in that instance, if it were you, that would be fine. That the president can come to Otafo, campaign against you, and at the same time say that vote for the MPP candidate.
Why not? What was the purpose for the campaign? The purpose for the campaign was to get his party candidate to be part of the next parliament.
Why then do you want the Fomena MP to be now on your ticket now?
He wants to. It is his fundamental human right. And that is why it comes back to issues of interpretation.
You and your like, are you not playing double standard with this issue?
How are we playing double standard?
You answer me.
But I want to understand why you think that.
Answer me with another question.
Because I want to understand why you think we are playing double standard. The Constitution is a living organism. If you go and read the Tufo versus Attorney General case, it is a living organism, capable of growth. The fact that there has been an interpretation to it in 2020 doesn't mean that the Supreme Court cannot depart from its earlier ruling, knowing very well that indeed the Constitution is a living organism, capable of growth. So my point is that it is an issue of interpretation, because what we are doing right here now, and what my other brothers are doing, is that we are putting rival meanings as far as the Constitution is concerned. And if you read the case of Akosa, Akosa will tell you that as soon as you put rival meanings, or two persons put rival meanings, as far as the interpretation of the Constitution is concerned, you take it to the Supreme Court for the Supreme Court to interpret for you. That is why the majority leader went to Parliament, invoked the original exclusive jurisdiction of the Supreme Court, that the Supreme Court should interpret the Constitution as far as 97 is concerned. So if you are putting rival meanings on it, it does not lie in the mouth of the Speaker of Parliament to interpret the Constitution, because that is not.
Do you say the actions or the ruling of the Speaker of Parliament the last week was coterminous to interpreting the Constitution, or he was just undertaking his work as a Speaker of Parliament, as enshrined in the Constitution that we have?
The Speaker of Parliament was smart to have said in his ruling that I am not interpreting the Constitution. I am only applying the Constitution. But mind you, there has been an earlier writ filed in the Supreme Court interpreting what the Speaker sought to apply in Parliament. And that interlocutory injunction, according to Espate Mofat, says that as soon as there has been an application in Parliament at the Supreme Court, that application is enough to stay in the hands of anybody who intends to take any action as far as the claims or the relief that is being sought in the writ is concerned.
Was the Speaker
so the Speaker of Parliament, I'm saying that.
I'm asking you, was the Speaker served at the time that he was making these pronouncements?
See, when it comes to issues of service,
as we even broadcast live right here on TV3.
When it comes to issues of service, it is regulated by Order 7 of the CI 47. Now, if I want to serve you, I have to come to you personally and direct the service. If you frustrate it, I have to put it as near as possible. That is what Order 7 is saying. In the event, in the event that you frustrate the service, I may have to go by way of a substituted service. But the Speaker of Parliament had already agreed with the Chief Justice and came by way of a practice direction that members of Parliament and Speaker of Parliament cannot be served on any other day apart from Monday.
For good reason.
And no, but you see...
For good reason.
No, but you see, the CI-47 is a subsidiary legislation. A subsidiary legislation that is subservient to the Constitution of the Republic of Ghana. If you check Article 157, Article 157 talks about how the rules of committee brings about the subsidiary legislation. And CI-47 is one of them. The Chief Justice, and if like the Speaker of Parliament, sought to amend.
Yes, he was serving.
Amend. And I'm saying that, but if you resist service. Listen.
Anyway,
because we're
joined by over 22,000 people watching currently on X. Used to be called Twitter. So for those of you who are used to Twitter, please go to X. You also join us. Over 5,000 of you also watching us on Facebook. And I asked a categorical question. At the time that the Speaker was making that ruling the last week, was he served?
No.
More so, the Speaker of Parliament categorically also had explained that they have an agreement with the Chief Justice in plain language. I'm not a lawyer, and so please pardon my language. And they call it a practice direction. That says that because members of Parliament to and fro will be working, if you want to serve them based on agreement with the Chief Justice, you serve them on Mondays, right?
Yes, and I'm saying that
And the rationale was that you don't obstruct their work at the time they will be working within the days of the week. So Mondays, per the agreement, was right. So I was asking, why not wait for Monday?
No,
he says that doesn't matter.
Because you see,
Vincent Asefo, you're a lawyer. Are you saying that the Speaker of Parliament was disingenuous?
Absolutely.
Frustrated service?
Absolutely, because you see.
How can you say that of the distinguished Speaker of Parliament?
The Speaker of Parliament, you see, party's direction cannot amend a provisional constitution, a provision in the Constitution. A party's direction cannot override a provision in the Constitution. A party's direction cannot override a provision in a subsidiary legislation. Article 11 is very clear when it talks about the sources of law. If you want to come by way, or if you want to make sure that you amend a subsidiary legislation, Article 11 is very clear as to how you go and amend a subsidiary legislation. You have to lay it before Parliament. How can a Speaker of Parliament, if like the Chief Justice, amend Order 7 of the CR 47 and says that members of Parliament cannot be served on any other day apart from Mondays? Who does that? Is that the law? Is the law at the bosom of the Speaker of Parliament to amend it anyhow he wants?
Have you challenged the law?
But we are in the Supreme Court. So I'm just saying that when it comes to issues of service, yes, as members of Parliament, we have privileges and immunities. But the privileges and immunities cannot topple a provisional constitution, cannot topple subsidiary legislation. Yes, because you see, because you don't understand what I'm saying. What I'm saying is that
because you are speaking too much English.
No. It is because when a certain law, and I have read Article 1, 2 to you. Any law that is inconsistent, any law that is inconsistent in the Constitution shall at the
so you're saying the Speaker was wrong, and that's why we have that. The contention is: do we need to have a stay of the execution of the ruling of the Speaker, and at the same time, having the Supreme Court encroach on the turf of Parliament?
That is not for me to say. And that is why we are going to go to Parliament and be part of the process, both of us. And I can guarantee you that when I get in, I'll be wearing my red smock, and then I'll be seated.
You're going to change into a red smock?
Yes. And I'll be seated on the right-hand side of the Speaker. But you see, Roland, when Vincent says, for example, that orders and instructions from the Supreme Court, if disobeyed, can constitute high crime. Well,
I'm not the one saying that's the Constitution.
Let it be.
That's the Constitution.
Let we, the majority members,
do not lead the Speaker into temptation.
And the Speaker
do not
be charged for high crime.
Do not.
For insisting that we have to defend the Constitution. Look, the entire legal process itself and the injunction and the service of it. Roland, you see, I don't want us to delve into the manner in which it was done, the speed with which the Supreme Court constituted a panel to deal with this issue in less than 12 hours. And the fact that an injunction had been filed even before an occurrence took place, that in itself is questionable. And very seasoned lawyers have questioned the processes by which this was done. Now, when you say that MPs, the Speaker, we all draw our authority, privileges from the Constitution, well and good. But so does the Supreme Court. The Supreme Court also draws its authority from the Constitution. And if you read the Constitution about the judiciary, it says justice is administered for and on behalf of the people. And we have a responsibility to also defend the very same Constitution. And you see, Roland, Article 97 G and H are very, very clear.
The Supreme Court sit on matters.
Very, very clear. And the Speaker, in his wisdom, when he presented his response to the call made by the now majority leader to pronounce on the consequences of the actions of the 4 MPs as evidenced by the Electoral Commission issuing the statement of poll, was very clear. It's not as though the Speaker doesn't understand the Constitution or he doesn't understand parliamentary procedure. And if you indulge me, Let me read a portion of what the speaker read to us. Role of speaker after he was invited. And then we will understand this. He says this. He says this. If the understanding of the provisions was futuristic, referencing Article 97 I and G. Listen to me carefully. If the understanding of the provisions were futuristics, MPs could freely switch parties or become independents during the term of a parliament and pretend to be representing the interests of people who elected him or her or the party on whose platform she wrote to parliament while paying loyalty to a different party or group of people with no immediate consequences. So the speaker narrated and laid it out very clearly that those who are claiming that the content as captured in Article 97 G and H was futuristic are saying that that provision is of no consequence because of what use?
And to you, it sounds alarming.
Yes.
So it means that somebody could be in the early years of their term, and when the calls are made or nominations are open, they decide to go independent. So
very clearly, what the speaker says is that if Article 97 I and G, Article 97(1) G and H were to apply only in future parliaments, it would render the provision effectively superfluous. By the time the next parliament is constituted, any MP who has defected or switched political allegiance during the current parliament would no longer be in violation of the provisions. The framers of the Constitution certainly could not have put this in the Constitution if it were to be superfluous. Therefore, the provision that has been made and the pronouncement on the speaker having been invited to make a declaration by the now majority leader on the conduct of these 4 members of parliament is watertight. This does not need any interpretation. It's as simple as that. And parliament must assert itself and assert its autonomy. We are dealing with a system that allows separation of powers. The judiciary has its domain. The legislature has its domain. And so does the executive
Clement,
arm
are you saying by going with your submission, you are even advising the Speaker of Parliament, Alban Gbagben, to stay on course on his ruling the last week?
Exactly so.
And defy the Supreme Court?
We have not said he should defy it. He should stay with his ruling.
When he has been
if he does what we know is right, as he pronounced in his response to the call made by the now majority leader, as many Ghanaians agree with, he would be in the clear. And if we are all going to suffer the consequences for doing what is right and what is lawful, let that be. Let it be documented that we have defended the Constitution and its content. In fact, it is not the case that the Supreme Court is beyond reproach.
Nani Osapon, if you take a look at all this, and I think categorically, you and I are the only people who don't play with the law. We only discuss the law as it is, in terms of just having a public comment or opinion on the subject.
They are only speaking plainly.
How do you think this tango that is ongoing between the 2 caucuses of the House, and then also the additional orders that are coming from the Supreme Court? Of course, we had the Chief Justice in the thick of affairs done. Perhaps a needless tension and atmosphere and insecurity in the minds of the ordinary Ghanaian just some few weeks to a major election. And you know, by history, each time we have a second term of ruling parties where we are expecting a transition, which we haven't had the same party transitioning to the same party to form government, we tend to have a certain tension in the atmosphere prior to that election.
If the defense minister and the Chief of Defense Staff had not instructed military to go and review it, we will not say that there is tension. You understand? I believe that we ought.
Let me hold you because we are here. We have free Christmas to enjoy. Dr. Tony Edu, distinguished politician and then also minister in the past NBC administration and a distinguished statesman has joined us. Dr. Tony Edu, good morning to you. And you have observed all that has been happening.
Good morning, Roland. How are you?
I'm well, sir. You take a look at the formative years in the run-up to having or ushering in this democracy. I remember as a young boy, I was watching the Constituent Assembly shown on television live.
Consultative. It was consultative.
Consultative, certainly. And shown live the ushering in of the Fourth Republic, etc. Do you think that all that has transpired the last couple of weeks, if not just a week or two, is needed just in the run-up to this election? And what do you make of it?
It's a shame that there is systematic executive and judicial attempt to destroy our constitutional system of governance. The Constitution and its provisions do not lend themselves to amendment by the Supreme Court. Acts of Parliament that goes against the grain of the Constitution is what the Supreme Court has the authority to interpret. Now, the current issue, Article 97 and its sub-clauses, they are all at clear. At clear means there is no ambiguity in the provisions and activation of that article. They have automatic application. Automatic application like strict liability offense under a criminal law. I'll give you an example of a strict liability offense. A driver caught driving without a license. You are guilty. You will not be given the opportunity to say, my mens rea was not around, so the prosecution will have to prove that I had a criminal intent. No, you've broken the law. The law is specific, unequivocal. Likewise is the provisions under Article 97. Now, the Supreme Court is interfering in parliamentary proceedings. The Speaker did not make a ruling. The provisions of Article 97 kicked in automatically. The Speaker applied it on the basis of his prerogative under the Standing Orders of Parliament. He did not make a ruling. He applied it. So where does the Supreme Court come in? To interfere with parliamentary proceedings and issue an order to stop. To stop what? To stop the operation of the Constitution. It is not the Speaker in Parliament that the Supreme Court is attacking. It is attacking the Constitution itself. By going to put a stop to parliamentary proceedings, what the Supreme Court is doing is that it is attempting to subvert the Constitution itself.
Are you there, Dr. Tony Edu?
Yes, I am here. I'm waiting for your next question.
And having served, looking at your illustrious career over the period, position of defense minister, you've even worked with the African Union, serving on an advisory board on corruption, etc. You take a look at the decisions that have been made, particularly in the life of this parliament, early on deploying soldiers, armed soldiers, and to the ordinary citizen will be even scary. And now we're just having our reporters giving us live feeds of armed soldiers again storming parliament. You look at your experiences, not only in the portfolio of defense in the government of Ghana, worked largely across the African continent, what signals do they send? Not only to Ghana, Africa, but the world.
The signal is sent is that the military is on a reckless journey of attempting treason. Treason is akin to Hitler's assault on the Reichstag in the 1930s. It shouldn't happen. And Ghanaians must stand up. There is no supra-constitutional body in Ghana. Only the Constitution rules. And Ghanaians must stand up and defend the Constitution. You cannot assault the Constitution and get away with it. You do that, they invade Parliament, they have assaulted the Constitution, and they are guilty of treason.
And I think I love the point where you bring in the invasion, especially within the period of the Nazi Party, etc., to Parliament, etc. If you take a look at the book that was written by Hitler, Mein Kampf, and how it got to spread the level of Nazism and socialism across Germany and its effect, and now we still know its effect today of Semitism, etc. Do you think we are on a path, when it comes to the Fourth Republic, of having politicians at the helm of affairs who seem to be leading the citizenry towards another path that was not intended by the framers of the Constitution that we have?
The past 8 years have seen the systematic unveiling of the face of fascism in Ghana. All constitutional bodies in this country have been invaded by the executive. What else do you need? What evidence do you need that we have a tyrannical president in power? He's not governing, he's ruling. He's ruling. Every constitutional body apart from Parliament has been invaded and bastardized by the Akufo-Addo regime. Why? Why? The Supreme Court issues orders which are contradictory, saying that the constituents of the four members of Parliament have a right to be represented. Didn't the people of South have a right to be represented over the past 4 years? Didn't the constituencies of Jackie Kwesi have the right? And yet they were stopped by the Supreme Court. Why? What is happening in this country? Our only refuge is not to the Supreme Court that was supposed to be the last bastion of defense of the Constitution, but the people themselves, because the Constitution represents the will of the people of Ghana. And every Ghanaian must stand up and defend the Constitution. This is not Parliament versus Supreme Court. This is Supreme Court versus the Constitution.
If there's a word of advice you give the Speaker as to whether to obey the orders of the Supreme Court or not,
he must stand firm.
He
must stand firm because he is duty bound. He is duty bound to stand firm. It's not just a question of whether the Speaker has power or whatever. The standing orders, which are a creation of the Constitution, as much as the Supreme Court is a creation of the Constitution, is under the auspices of the Speaker, and he must act in strict accordance with the standing orders.
Dr. Tony Edu, thank you very much for your contribution this morning. And I love that you always watch TV3. Always watch TV3 New Day as well. Thank you very much, Dr. Tony Edu. And Nani Alsapong, you here for the distinguished politician and statesman, having worked across the continent, occupied key ministerial positions, so to speak, bring his experiences to bear. You think that for all that he said and what we're discussing today, we need to put all these matters into perspective in the House when we get proceedings ongoing, especially presided by the Speaker?
The Speaker has a responsibility. He has an obligation. He needs to honor it. And as to how to honor it and to go by it is not determined by us. He has a working document, the Standing Orders of Parliament. And so, personally, I sit here, I believe in the Speaker, and I trust in his judgment, because we have put him there to work for Ghana. You see, Roland, when Vincent was making his submissions, he wanted us to understand that when you have an intent to commit crime, in itself is not a crime. But I do not think that was what we were taught.
No, but I never said that here. That's not what I said.
I'm not a lawyer.
But you can't
He
use
said
that
he didn't
analogy
say that.
here. You
Let's
can't use
continue.
that analogy
continue.
doesn't work here. It
Continue.
doesn't work here. Not applicable.
But he did make mention that the people only have intentions. Do we agree that you made that statement?
They have intended or they have declared to be part.
Are you talking about intent when we're talking about crime, or you're just talking about the actions they've taken?
The actions and you play with words too much. It's the same
Because
thing.
in
Intentions and
criminal law,
intentions.
Go
intent
ahead.
alone
Go
is
ahead.
not criminal.
You understand? So you would have an intent, I believe is in about 4 forms. Those of you who have done law. We have the one that you have the knowledge about it, and for that matter develop the intention. The one that you seem not to have knowledge about it, and so you are negligent, and so it happens, and the other ones that follow. So with these 4 people, they know the consequences of their actions, and they developed the intentions to commit to the actions,
And they executed.
We should also be added with an
and
action.
they
Please,
went
excuse me, let me
ahead
talk.
with the procedures. And Electoral Commission did publish the notice of poll. Now, let us agree that
The
an
Electoral Commission did
election-
publish the notice of poll.
anonym. They've started printing the ballots.
Notice of polling for the free.
What they are
Social
saying.
instrument. Subsidiary legislation. How is that bigger than the
So-
Constitution?
You would have a situation whereby, Roland, you put in your resignation to Media General. Then Media General and you yourself, you are aware that you are going to work with another media house.
Whilst I haven't fully resigned.
When you've not fully resigned, because you've given them notice and say in 2 months you would go. And then Media General is having a crucial meeting that would be discussing strategies of how
You still sit here.
In relation to our
and work.
competitors.
Exactly.
You still
how
sit here and
to
work.
deal
Okay, sorry. Shh. My goodness. Hey, boss.
so how to deal with the issues and the matter. Now this is what is happening. Media General would do itself harm if they allow you, Roland, to sit in that crucial meeting. And I do not think your general manager, even if he or she does not read your HR document, would allow you the space, a minute, to be part of that strategic meeting. Roland, you see,
That's
the issues are simple.
earlier. It just doesn't work.
It won't work.
Nobody does that.
And you see, when it has happened, you open the floodgates. Because once somebody has put in a notice to move out of a political party, all right? I'll give you another example. Nana Ohininto declared his support for Alan John Kojo Tramantin because Alan's going independent.
Nana Ohininto.
Nana Ohininto, by virtue of his position as a former general secretary, was a member of the National Council. Is Vincent telling me that today, when Ano Hininto wakes up in the morning and there is a national council meeting, he will be allowed to sit in the council meeting? No. And so if Cynthia Morrison will not be allowed to sit with the MPP caucus during committee meetings and to take critical or to take part in critical discussions in Parliament, she will. Because you will not allow her to sit with your caucus to think. She will. It means that it is going to affect her performance as an MP. This is clear. Roland, see, what is happening today would go down in history and we would all remember.
Why?
But what we should be cautious about is our continuous use of the military. In my view, this is an attack of the Constitution. If these military guys are allowed to invade Parliament as we see in the footages, it is an attack on the Constitution, and the Council of State and the Ghana Peace Council should rise to the occasion. They should call the defense minister, call the chief of defense staff, and caution them. We are not, Roland, we are not in a war zone. Why are we always causing fear and panic? What is happening in Parliament that we need a presence of military? What is happening in Parliament that we cannot solve that unless we have military men who have covered their faces as if they are going to a war zone?
You think that's dangerous?
We have Galamsey to deal with. You are in Accra, more dire condition. We have Galamsey to deal with. We have other high crimes to prevent and to protect our borders. You're not dealing with it.
You're saying there's no state of emergency for which we need to have the military massing up
Well, is it a takeover?
at the precinct of Parliament?
Is it a takeover?